think we might begin. I'd just like to begin by acknowledging the Wurundjeri people of the Kulin Nation. I am absolutely delighted to welcome you all here to the launch of the new research seminar series. Today is the first in a series of reasonably high-profile seminars launched in collaboration with the Deakin Law School and its long-time supporter, Sladen Legal. Sladen has a strong reputation for innovation and forward thinking, and it's been a firm supporter of the Deakin Law School over the years. Sladen has established representatives on the School Advisory Board and also a history of employment for Deakin Law graduates. So we're very happy to collaborate with Sladen to present this new series and to quote a little bit from the eulogy of Charles Sladen, the 6th Premier of Victoria. Charles never paltered with conscience. He never took an unfair advantage of his own position, but lived for the public good. And that's the aim of this series, to coordinate presentation of keynote expert presenters that are capable of discussing and analysing topical and contemporary legal issues. So we're wanting to do this for the public good. We're wanting to inform, to evaluate and to debate. And what better thing to debate at the moment than this issue? Simon, and I do not want to take any of his thunder, he's got a fantastic paper for you today, but I'd like to just outline broadly the concerns. Simon is here talking about proposed changes by the federal government to the Racial Discrimination Act. The federal government, as I'm sure most of you are aware, has proposed changes to Section 18C of the Racial Discrimination Act under the Freedom of Speech repeal of Section 18C bill. This would repeal protections that currently exist in the RDA against what is known as hate speech. This has been done on the grounds that there is an increased need to protect freedom of speech being an essential feature of a just political society. The promotion of free speech and the repeal of the protections against hate speech do raise the spectre of racial vilification and the possibility of a dilution of the capacity of anti-discriminatory laws to protect marginalised, weak and disadvantaged groups. Any dilution to these laws which diminishes the protection against such discrimination is potentially dangerous. To this day, I continue to be moved in my property law classes by the speech of Brennan in Melbourne, who said, and I quote, "It is imperative in today's world that the law should neither be nor be seen to be frozen in an age of discrimination. Racial discrimination has no place in the contemporary law of this country." And we know that things are getting a bit frosty if we are starting to remove some of the protections in our anti-discrimination law. Invective can contribute to the perception in society that those attacked are less than human. Barbaric and uncivilised was the way or the characterisation given to Indigenous inhabitants pre-Marlborough. This actually contributed to the absence of a legal identity for the Indigenous community and to the absence of any acknowledgement of native title rights. Invective can produce a situation where those attacked become less able to defend themselves against the abuse generated by the promotion of free speech. In such an environment, victims are often silenced. This is all the more concerning when the victims represent minority or marginalised groups who lack a clear voice and therefore expect and deserve the protection of our national law. Sometimes the state must act to show its solidarity with vulnerable minority groups and its commitment to equality. Laws prohibiting racist speech are an important component of this. Protecting democracy may actually involve repressing speech. That's enough from me. I'm going to leave it there. And on this note, I'm handing over to Megan O'Connor, who is from Sladen Legal.
Thanks, Sam. I am one of those Deakin Law graduates that Sam mentioned, and I'm now principal at Sladen Legal Sladen Legal is a Melbourne-based law firm that's really passionate about those things that Sam talked about and working with private enterprise. We're part of the Lantern Legal Group that also owns regional law firm Harvard Andrews. And we've had a long-standing association with Deakin University. As Sam mentioned, we've had continuing involvement in the Deakin Law School Academic Advisory Committee, but our relationship also dates back to the early days of forming and developing the law school. So we're very proud to be able to continue our relationship with Deakin University as a sponsor of this series, and particularly opening up with the series today that we've got with Simon. So it's great to see so many of you here today, and we look forward to seeing you at the future seminars. Thank you.
Okay, now it's my absolute pleasure to present Professor Simon Rice, OAM, Director of Law and Social Justice at the Australian National University. Simon has worked extensively and tirelessly in poverty law, anti-discrimination law, human rights and access to justice. He has been the Director of the New South Wales Law and Justice Foundation, a board member of the New South Wales Legal Aid Commission and a consultant to the Law Reform Commission. Simon was awarded a medal in the Order of Australia for legal services to the economically and socially disadvantaged. We are privileged to have Simon speak for us today.
Thank you, Sam. Good afternoon, everybody. Good afternoon, people who are not here but who are watching you remotely. When preparing for today, I read a little about the Wurundjeri people of the Kulin Nation, and I came upon this observation from Don Garden's History of Victoria. He said a large proportion of colonists moved from a sense of superiority to a feeling of contempt. It was 150 years before expressions of racial contempt became unlawful. And it was not only in that intervening period, but despite the law, it is still the case that the Wurundjeri people and all of Australia's Indigenous peoples are subjected to contempt. Perhaps more subtly than before, but no less demeaning and hurtful for that. It's in recognition of the price that they continue to pay for the loss of their land and their continuing struggle for recognition that I acknowledge the true owners and custodians of this land and pay my respects to their elders. I am honoured to be giving the inaugural presentation in this new series of research seminars presented by Deakin University School of Law and Sladen Legal. The research seminars, as you know because you're here, are open to the public and will be captured on video and posted online specifically to generate discussion and debate. So it's apt that the series begins with a perspective, my perspective, on the vexed issue of free speech. From another time and in another culture, Hans Christian Andersen's test for the most sensitive of creatures, a real princess, was whether she was uncomfortable sleeping on a pile of soft mattresses under which was a pea. Australia is a very comfortable place, comfortable like a pile of soft mattresses. Australians, in their comfort, fail the pea test. Under the mattresses is the small, hard, persistent pea of racism. If we are aware of it, we fail to acknowledge it. We don't allow the persistence of racism to disturb our comfort. Ours is an unthinking, unearned comfort, in the intended irony of Donald Horne's Lucky Country, by which he wanted to say that we do not so much make our society as ride our luck, based on inherited British origins and the blessing of natural resources. Horne's view was that we've never earned our democracy. We simply went along with some British habits. One of those habits was to assert the supremacy of white, if well-tanned skin, and Anglo-European culture, if not especially cultured. The racist pronouncements of our public leaders well into the 20th century are notorious, as is our history of racist law and policy. But it's true that most of that is indeed history. Behind us now is formal fact. What we thought was a necessary protective cover over the comfortable mattress of Australian life has been stripped away, in large part by anti-discrimination laws and the modern sensibilities and policies that produce them. But underneath still lies the hard P. If I could rewrite the fairy tale, I'd call it a jagged rock of racism. And we as a society remain largely insensitive to it. The insensitivity, I think, comes in part from the satisfaction that we perhaps justifiably feel that racist law and policy is behind us, that we have anti-discrimination laws, that we commonly condemn open racism, and that we are formally an equal society. That satisfaction is what leaves us insensitive to the persistence of racism. My P under the mattress is the casual racism that our Race Discrimination Commissioner, Tim Soutphommasane, has been drawing attention to. It is the unthinking and unconscious racism of ostensibly neutral practices and policies, of offhand remarks and asides, of customs and habits which persist under formal guarantees of equality. Even the words racism and racist, let alone their full import, are confronting and controversial. In legal proceedings, an allegation of racism is commonly required to be proven very conservatively on evidence of the highest probative value because of the widely accepted moral turpitude implied by such an allegation. Condemnation of what is seen to be racism is so quick and absolute that there's no room to dwell on the idea of race, to explore its continuing presence, to suggest that it might take forms and occur in places that we fail to see, precisely because we don't tolerate the idea of it. The protestation, "I'm not racist but," rarely stated these days, but often implied, is an attempt, as I see it, often to make a finer distinction than the prohibited idea of racism allows. It tries to say that there is a view of race that is to be condemned, and that is racism, but there is also a view of race that warrants public discussion, that should be permitted without being caught up in the prohibited idea of racism. Our terminology is inexact. We're impatient with the time necessary to explain ideas that can't be captured in a single word. So much is taken to be implied by the term racism and racist that there's no room for related discussion or to introduce nuance or refinement into ideas of race difference in society. So, when I say that the P under the mattress of Australian life is racism, to which we are insensible, I expect a hostile reaction. We know about racism, and we don't tolerate it. We say quickly and forcefully, we are not racist, at least not in the to be condemned for intolerance sense of the word.